I will oppose it until I see something which is reasonable. Because what happens is, obviously, someone is going to introduce this, but on the operational side, we will discover that, like you said before, the devil is in, or the hell is in the details. And we are left with hell because no one takes care of these details later on, or no one pays attention to this.
Right,
and no matter what it is, have you ever seen any kind of legislation, including all the mandates which they come up with, or federal funding of special ed? Did you ever see that something worked according to what was planned? Absolutely does not. Because these details are left behind, and then the community has to deal with the consequences. So this does not have these safeguards, and I don't feel that we are opposing I'm proposed to oppose to binding arbitration until I see some legislation which makes sense and that protects the schools from, for example, answers the questions that we will not be facing with giving someone a raise and at the same time cut the program because our hands are tied. Here you have 4.5% cap, to which you have to stick. And now let us assume that right now in these particular times we would have an arbitrator's decision that we have to pay everyone 2% raise, and there is no change to the healthcare system as it is right now. What would you do?
My question is the motion that we oppose this legislation because we oppose binding arbitration, or we oppose this particular piece of legislation because we feel it doesn't safeguard our interests? Because that will make a difference on how I vote.
Yes, excuse me, I'd just like to caution us all as we go up to the State House and we review all these bills and we read every word, what happened with 3050 when they passed that and we have to obey what they said, but they're part of it that said they were going to pass a funding formula, they haven't yet. Plus they said they were going to gradually increase to 50-50. It used to be 60-40. They said they get back to 50-50 and they're going backwards. We obey the law, but they don't have to. Also, that little bit also, they dangled on the end of the 4/5 vote of the council or the town meeting, and now they put the word also on the end of it, so people don't know if you mean the town meeting has a vote or the council has to vote 4/5. This is so, you have to be so careful with every single comma and word of this, and that's what I think we're going on tonight, what we have before us. You know, and I don't think you think this has a safeguard in it that you want.
No, but I also don't want to give the impression that I would be opposed to pursuing an adequate binding arbitration bill. So if the motion is that we do not support the particular bill that has been introduced,
I think that's
due to our reasons, I could support that.
That's all we have.
As long as the language does not become more general than that.
We can only vote on what we have.
We cannot oppose the concept.
Right.
All right, I was wondering if that was where you were going with it.
No.
So far, all the examples we have seen how this concept was implemented, not encouraging.
I think the answer to
Yeah.
that is
Thank you. Well, I was looking at the sample letters that were sent to us, and I would not be willing to put my name on the sample letter.
the committee just simply needs to forward I think you need to forward the committee as opposed to
This
House
legislation.
7581
The specific
because
Correct.
of the reasons we've stated. Or just say we propose to this bill, and leave it at that. I'm not.
Right.
We don't need
We
to
are
say
not
we
voting
don't-
on someone else's letter.
No.
No.
Okay, we're
no,
not.
I just
Say
put
we
those.
agreed
No,
to send this
I
letter.
put those just
Sam.
for your. If you wanted to do whatever.
Okay. So we'll call the vote.
So could you just repeat the motion, please,
Well,
so I'm sure?
The motion is, Elaine's got the minute. She's the open session
To
person.
express opposition to such legislation and authorize a representative to go and oppose this piece of legislation. Now, this is just the binding arbitration piece,
Correct.
And I
correct?
recommend that you.
Specific legislation.
Specific bill number.
Yep. You have this number here?
7581,
Yeah.
House 7581.
Yep. 7581. Okay. So now that this is clear, All in favor?
And the second piece of legislation is Senate 2603. I believe you need to take a motion. to discuss
I'm making
it.
a motion to propose this legislation as well, because this will simply allow the bargaining unit to write the old contracts at the time of purchase. Second.
Although in this case, the existing contract continues in effect until such time as an agreement has been reached, at which point the terms can be retroactive.
Second.
Attorney Robbins, I'm sorry.
Partially, this is in response to Judge Silverstein's ruling in East Providence, where he said the contract's over, and you have the right committee to unilaterally impose contracts. It does not continue. The only thing I would say about this, by way of offering any legal advice, is it is a very complex area that the legislature has laid out for you. One of the things they have done is pass several statutes that say you have to run a balanced budget. Now, and in that language, and the judge was, and this has created tremendous consternation in myself and other attorneys who do this kind of thing, he said that the balanced budget language in the statutes and in the Carullo Act, notwithstanding any other statute, that preempts virtually any other state statute. In his case, he was talking about teacher contracts. But that logic could go to the BEP, could go to busing, could go to rights of students. We don't know how far that's going to go or what the Supreme Court is saying. In other words, what they're saying is that your obligation, what the judge seems to be saying is, your obligation to run a balanced budget is paramount to the rights not only of teachers, but of students. Now, if this particular bill is passed, it would appear to elevate teachers' rights to a continuing contract over the rights of everyone else in the school system. And I hope I'm being clear in how I'm saying this. I mean, for example, children's right to busing is based on a statute passed by the legislature. They said if you live beyond a certain distance, you're entitled to busing. Statutory right of children. What Judge Silverstein said was the balanced budget in the Carullo supersedes that. So if you're out of money, you can say to the parents whose kids live in the far ends of town, we're abolishing busing. And we have a right to do that to balance our budget. Now, I'm not saying that's the law, but a lot of people who think about this and deal with this law all the time are very concerned about it. So I just want to point out to you that it appears the legislature here may be giving contracts greater rights than everyone else in the system who has statutory rights. I thought I'd bring that to the school committee's attention.
Under what circumstances would we be entitled not to simply let the contract roll? In other words, the contract expires. We can just change anything about it we want?
That's what Judge Silverstein, well, it's not quite that simple. But what he said was, in the circumstances in East Providence where they were projecting a significant deficit, that he said under those circumstances, that notwithstanding language in the statute, about collective bargaining and all that stuff, goes out the window, and yes, you can reduce, in their case, I think they reduced it 10% or 20% or some number they reduced the salary of the teachers there. They said, we're going to reduce it X number of dollars in order to balance our budget. And he said that was right. That was okay.
But